but I've had great marshals, I've had great clerks, and I've had substitute JEAs while I've been here for the 3 weeks, and I'll be here next week also.
On the record with case D19C.
Will counsel state their appearances, please, for the record?
Lorien Cole, bar number 11912, on behalf of who is present with me in my office.
Okay.
Good morning, Your Honor. Patricia Marr, bar number 8846. I'm appearing via Zoom, obviously. I don't know where my client is at. I spoke to him this morning and expected him. So I'm uncertain as to why he's not on.
Is there a way to get a hold of him?
Yes, Your Honor.
You want to take a minute to see if you can get a hold of your client?
May I, Your Honor?
Yeah, please. We'll just be at ease.
Okay, awesome. Thank you. He will be joining us momentarily.
Sure.
We're back on the record.
Okay, this is plaintiff's motion to reconsider, alter, or amend judgment and for attorney's fees and costs. There's an opposition from the defendant and also a counter motion for attorney's fees. So we'll have the first of all, plaintiff's motion. Go ahead, counsel.
Thank you, Your Honor. For the record, Lorien Cole, bar number 11912. Your Honor, I know that Your Honor did not hear the trial in this case, but we are asking for a reconsideration of the issues that were put on the record in relation to the facts and circumstances regarding both the dad's intoxication during a child exchange that was minimized and deemed irrelevant to the custody decision. So just for a background, Mom and Dad lived in Las Vegas. Dad is asking to relocate to Texas. During that relocation, there was an order that stated that that neither party were to be intoxicated. And when Dad came back to Las Vegas, he was intoxicated at the child exchange at the airport. We had a police officer testify that Dad was intoxicated at the time of the exchange, and the child was unable to be transferred to Dad during that exchange. In the ultimate decision, the trial judge disregarded that evidence, which is very important because it was a pattern of behavior of Dad's in the past, given that he has had a previous DUI. There was also the factors that are under Schwartz that were not completely considered by the court, which is one of the reasons why we're also asking for reconsideration and reopening of this issue. One of the main ones was the facilitation of a relocate completely to another state and have complete primary custody and control of the child with minimal contact to the other parent. There is a very important aspect of facilitating a relationship, and it was very clear from the trial that Dad had been controlling and restrictive with Mom's contact. That was actually pointed out even by the trial court judge during the trial. Dad had, there had been a mix-up with a minimal amount of hours during an exchange, and Dad just withheld for an entire holiday on multiple, and that information and evidence was minimized in the decision, given the fact that the parties are now having to facilitate contact through airplanes and airports and long distance travel. That's especially in that maybe it's a good idea for the parties to be in a different state because they have a difficulty co-parenting. And we find that to be an extremely concerning decision and finding, because now, even after the decision was rendered, my client was again she was withheld visitation even on December 20th after the decision was rendered. And Dad would not give her the address or location of where the child was the night she was supposed to pick the child up. I know this is information and evidence that happened after the trial, but it's just an example of continuing behavior. And there was example after example at trial of when Dad had withheld contact to Mom during her custodial time. And there was always an excuse and a reason why he did that. And that evidence was minimized at trial which is extremely concerning considering dad is asking for full custody in another jurisdiction over this child. Dad also testified that he had to move to another state for a employment position, but by the time we got to trial, there were 3 different jobs he'd already had in Texas. And one of the job he had at that time at trial was a job that he, first of all, has 2 branches in Las Vegas. Dad testified that he was doing so well with the company that the CEO came and gave him a ride around and to look at different, a special occasion that he got a ride with the CEO. So the fact that dad had to move for a job was also not credible. Dad's job didn't even last a month or 2 before he was changed jobs again, and he does not have any reason to be in Texas given the fact that his job is here in Las Vegas. And that evidence was not considered or laid out in the decision. And then there were other issues that were of grave concern about dad's co-parenting. He was ordered not to record conversations between mom and the child during their video calls, yet he admitted that he was recording them, and the judge had to make another order telling dad to stop doing the recording. And at the end of the ultimate issue, Your Honor, is that the evidence at trial really resulted in a decision that did not comply with the factors under the statute for relocation, which are essentially the Shorts factors, and that dad's concerning intoxication and abuse of alcohol, as well as and the main factor being the failure to facilitate a relationship, should have resulted in a different decision from this court, ultimately at the trial for his request to relocate. I know that Your Honor was not the trial court judge, but we are here on a request to reopen and to reconsider the decision. I just want to address one quick legal argument that dad made, and that was that there was an untimely motion filed. Technically, under the local rules, a request to reconsider should be filed within 14 days. That's usually concerning a motion hearing where someone is unhappy with an order. In this case, we filed it under the rules of civil procedure, under Rule 52 and 59, which is also a tolling motion, and that was timely. And I will reserve for now. Thank you, Your Honor.
Thank you. Opposition?
Oh, yes. I don't even know where to begin. Your Honor, this trial spanned the course of several days, with the plaintiff taking the bulk of the time at trial. With that being said, my client was granted permission, it's been almost a year ago, to relocate to the state of Texas, where he has resided since. He is one of the top salesmen in the company that he's working for in the country. And his relocation to the state of Texas has been nothing but advantageous for not only the child, but obviously himself as well. I've heard a lot of inaccuracies that have been represented to the court, particularly concerning as counsel's representation that there's a history of alcohol abuse. That is not accurate, Your Honor. In fact, he did receive a DUI, but that was approximately 6 years ago or more, in 2018. With that being said, I can't stress enough the length of time that the judge presided over this hearing and heard hours and hours and hours of testimony. There's a plethora of evidence that she considered. She considered the Schwartz factors, and she also considered the best interests of the child. And their star witness, an officer, did not find my client intoxicated. It's laid out in our opposition and our counter motion, but there's no basis for this and for the motion for reconsideration, and that's why we're asking for attorney's fees. This case has a long and tortured history of the plaintiff, and everything, the arguments against what the plaintiff has just stated are in our opposition, but I want to go a step further. This case has been up on appeal and back down. It's been before numerous judges, Your Honor, and this court, Judge Charter, took it as if she, without any regard to the history, a fresh start, a fresh basis. And even with that, she still found that the basis for my client to relocate to Texas. The alcohol abuse, I don't want to be unkind, but it's laughable at this point. Their star witness said, that was the officer, he didn't conduct a field sobriety test. He did not see that my client was in such a state of intoxication or even intoxicated such that the child could not go with him. It's just a meritless motion, and it's disturbing. There is a pattern in this case, and judges prior to Judge Charter found that. It's a Hail Mary attempt, and it has absolutely no merit. And my client bends over backwards to co-parent, and interestingly enough, what Judge Charter did find, and I invite the court to review the record if it's so inclined, is how demeaning the plaintiff is to my client. She calls him a loser, tells him she feels sorry for his new wife, and on and on and on. She made findings of fact, Your Honor, that are very compelling for this move. And Justice Cherry, you're in the Supreme Court. We don't replace the trier of fact. She's the one that presided over this. She witnessed the credibility of the witness. She watched their behavior. She heard the evidence. And what they're asking for, and they're probably very happy that they have another new judge, but what they're asking for is a redo on issues that have already been heard and decided without error on behalf of the trial court. She took, I would surmise that Judge Charter went above and beyond to ensure that her decision was bulletproof, so to speak. There's absolutely no merit to the motion. The DUI was in 2009. What is that? Math on a Thursday? That's so long ago. But the plaintiff will use anything she can, anything, to try to get a result in her favor. But unfortunately for her, the law should prevail, and Judge Charter applied the facts of this case to the law. And I don't know if the court wants me to answer anything specifically. I'm happy to do that for the court.
No, thank you. I'd like to hear the reply, though, from the plaintiff.
Thank you, Your Honor. There's just two issues I want to respond to with what Ms. Marr said. One was, again, her stating that my client called the dad a loser. And this is an important point because, again, we're repeating false facts from trial. So, whose dad, he testified that my client had said he was a loser, and that became one of the findings from the trial court's decision. But if you go back to the record, that's never anything my client ever said to dad. She never called him a loser. That was an incorrect statement. So some of the findings, and actually quite a few, were just repeats of what dad had testified to. Going back, she made some comments, just when they were talking about, and I quoted them in my motion, but never once did she use a derogatory name towards dad. And that was something that was made a finding at trial, which is another concern about taking someone's testimony and characterization about how the parties communicate and assigning fault to my client for that. Secondly, there was a comment in Ms. Marr's argument about domestic violence. First of all, my client never was convicted of domestic violence, and that was so prevalent in the decision that my client had convicted domestic violence or engaged in acts of domestic violence. What happened, there was a situational incident that occurred while the parties were separating and during their breakup,
And one of the previous judges found that she thought there was enough there to find that lower standard in the original custody decision. However, it's been so many years since that original finding, which again did not result in a criminal conviction. And that was used against my client to say that there was a presumption against her in this decision. And again, nothing in the record from years now has shown that my client has ever engaged in anything close to domestic violence. And the alternative, there was so much evidence about the coercion and controlling tactics of dad during the litigation, to the extent where if mom was an hour late to an exchange because she got a mix-up on the time, he withheld the child the entire weekend and ignored her messages on the app. When she went to Donna's house, because that's where they did the exchanges, she didn't have supervised visits, that's just where they exchanged the child. That was a new place that the court had ordered them to exchange. Dad didn't think she did the enrollment paperwork, even though she had done it, so he just didn't show up and didn't bring the child. She missed out on long periods of holiday visitation, and this is coming from a parent who has primary physical custody, and then just ignored her when she went on the app to talk to him and say, look, I'm here, where are you? She's even sent the police over to his home to do a well check because she missed her whole visit multiple times. There was time after time. That's why I testified for so long, because of how much time my client had lost with this child due to dad's coercive tactics. Oh, you were an hour late, and then I was in a meeting, and then I was out of town, and I was out of service, and I just never looked at the app. So you missed your entire Labor Day weekend holiday. It was one thing after another. She missed her entire Christmas holiday because he said she didn't enroll in Don's house on time just to do the exchange. When that morning she had gone down, finished the paperwork, sent him a message on time, told him she was there waiting. And this happened over and over to the point where even the judge had said that she was extremely concerned about dad's controlling behavior. So I just want to make sure that it's impressed upon the court that DV is not an issue in this case against my client. Yet for some reason, even though there was no testimony about domestic violence, it ended up being a major theme in the order. And that was another very concerning part of the decision that we would like revisited. And with that, I will submit. Thank you, Your Honor.
Thank you to both counsel for the fine arguments and the briefs in this matter. They were very helpful. This judge who's substituting for the vacant position, which has now been filled as of yesterday, which is nice to hear. I took a look at this. Please note that I was the attorney for Schwartz in the original Schwartz trial before Judge Mendoza, John Mendoza, back when I was in private practice. So I'm very familiar with the MOVE statute. It was a very contentious hearing, the Schwartz case, and most of these cases on relocation are contentious. I'm going to deny the plaintiff's motion, but let me tell you why. I've got some good information here. The motion for reconsideration, other than one that can be brought by Nevada Rule Civil Procedure 50, 52, 59, and 60, must be filed within 14 days after the service of the notice of entry. The notice of entry was filed and served on 11/18/24. The last day to file the motion timely was 12/1/24. Even if the motion is considered timely by another court examining this, the decision is clearly not clearly erroneous, and there's no mistake, inadvertent, surprise, or excusable neglect that would warrant the setting aside reconsideration of the decision. The court weighed the evidence and gave it its weight. None of mom's arguments would persuade this court to modify the decision. Therefore, I deny the mom's motion to reconsider. Defendant, I would also deny dad's counter motion for attorney's fees and costs. Mom's motion, and I want this to be clear to, especially to mom, since I'm ruling against her. Mom's motion was not unreasonable, was not frivolous or vexatious. The parties GF-DF filed on 10/1/24 suggest they both have sufficient income to pay their own attorney's fees at this point. I do want to stress to both counsel that I feel the best interest of the child was met by Judge Charter and also that the Schwartz factors were found to be sufficient in this case. But I do want to congratulate both counsel. This was a tough call for me, but I believe that Judge Charter was correct, and that I'm correct in denying this motion for a reconsideration. Thank you.
May I make one comment for the record?
I prefer not.
Okay, it just had to do with the timing of the rule, so.
Prefer not. You can do that if you want to take it to the Supreme Court or Court of Appeals. But I do want to say
Absolutely.
your argument was very, very, very convincing. It just wasn't legally sufficient for me to grant mom's request. And I'm hoping that there's finality here now. If there is, that's fine, but certainly both parties know that there are rights to go past the district court, the family division of the district court. But I appreciate both counsel in this matter. You're very, very good, courteous to each other, and very professional. Thank you. And I'm going to ask plaintiff to prepare defendant to prepare the order in this matter.
Sure.
And I'll give my bench memo to the clerk so she can make sure that that when she does her minutes that they'll be complete. Thank you both.
Thank you, Your Honor. May I ask
Thank you.
Your Honor,
Yes,
may I ask you a question?
it depends what it is. What?
You stated that the seat for Department Y had been filled. Who is the?
It's the hearing.
Asked her, Miss White, I think it's, her name is White, Adrienne White. I talked to her yesterday, and I told her about the chambers and everything, and told her I was ready to, I've been here since the 3rd of this month. I know that Judge Moss was here before me when Judge Charter retired in November. So God love the law clerks here. They've been very helpful because I don't have a law clerk or a JA, but I've had great marshals. I've had great clerks, and I've had substitute JEAs while I've been here for the 3 weeks, and I'll be here next week also. And also the law clerks have pitched in and really helped me with bench briefs. And I told them that when they go for their jobs, they should say that Senior Justice Michael Cherry thought they did good work. So I just thought both counsel would like to know that.
Well, that's good to hear, and I appreciate that. I guess I'm out of the proverbial loop. I had no idea, so it's good to know.
I found out from another judge who was walking down the hall and said, by the way, Cherry, you can hang it up pretty soon.
Aw, well, you will be missed.
Thank you.
Hopefully we'll see you again. Thank you, Your Honor.
Thank you for your time.
Have a good day, both of you.